Okay. Is it live yet, YouTube guys?
Yes.
Judge.
At least it
All
says
right.
live in the top corner.
It is. Okay. Let's go ahead and proceed, guys.
Yes, Your Honor. This case is a case from a motor vehicle accident in 2017. It was filed in 2018. Dr. Duffy is a controverting doctor for defendants Burke and Alan Grilliot. He is attempting to controvert Miss Maria Morales's treatment and bills for her pain management therapy, anesthesia, radiology, durable medical equipment, and prescription medications. Dr. Duffy is an orthopedic surgeon who practices in Collin County, and plaintiffs moved to strike his counter affidavit on the basis that his counter affidavit only addresses causation, which is outside of the scope of section 18001F. He's not qualified as an orthopedic surgeon to controvert every type of doctor's treatment and or bills. His counter affidavit lacks any reasonable notice of basis for his opinions. Again, his opinions are simply that her treatment and bills since 2019 are not reasonably related to a previous car accident. And also his opinions and his counter affidavit are unreliable and conclusory without any basis or merit. He does state throughout his affidavit that the treatment and bills are not reasonably related or that there's no relationship. He never states that any of the treatment specifically is not necessary or that any of the bills were not reasonable. Therefore, plaintiff doesn't really have any clue on which treatment or bills or the basis for why he's trying to controvert specific modalities or specific services and whatnot. And for those reasons, we move to strike his counter affidavit in its entirety.
Okay.
Yes, Your Honor. Your Honor, this is Dana Woods for defendants, the Brilliets. And number one, Dr. Duffy's affidavit does give reasonable notice of his opinions, which is the basis for 18001, which is to give reasonable notice. And I think that's been given here. I do agree that the issue of causation is intertwined with necessity, which necessity is certainly one of the elements of an 18001 affidavit. And I think that Dr. Duffy does specify why he does not find that some of this treatment was not necessary. Specifically, in this case, is a little bit complicated by the fact that plaintiff had a prior accident in 2015. And so Dr. Duffy does state in his affidavit that while he doesn't think that her injuries were caused by our accident, they were exacerbated. And he definitely says that he sees that there's been an exacerbation. And that's based on the fact that there were MRI readings for both accidents, both 2015 and this accident in 2017, and there was no change to her diagnostic condition. So he does find, though, that our accident, or excuse me, the 2017 accident could have exacerbated. It is inaccurate to say that he does not find that some of the treatment is necessary. In fact, he says that the treatment that she received, including some medial branch blocks and epidural steroid injections through July 12th of 2017 were reasonable. And he does not dispute the cost of those charges, which he's not required to dispute the cost if he doesn't have a problem with it. So this affidavit does not really deal with cost, it deals with necessity. And what he says is that the treatment was reasonable for this exacerbation, and he says it's reasonable through July 12th, 2017. And the reason that he states that date is because that's basically when she is released from treatment. And at that time, her symptoms were improved and she was doing well.
Counsel, I'm looking at his report. I'm a little unclear. So is he just trying to counter the treatment from 2019? And if so, what treatment is that exactly?
So she has that 19-month gap between July 12, 2017, and then when she goes back in, I believe, February of 2019. And that's what he's saying, is that, look, she was doing well and she had improved in July of 2017.
Okay, so
Therefore,
wait. I'm not sure I'm specifying what my concern is very well. So
okay.
she had treatment in 2017, the plaintiff did, and then 2019. He's attempting to counter just the 2019 treatment. Is that correct?
I believe so, yes.
And the 2019 treatment is which medical providers? Because it doesn't say.
Right. I think he just says that, well, I think that is part of, and it's going to be, correct me if I'm wrong, but that's going to be Momentum Spine that she goes back to in 2019. And that's who she had already treated with before. So he's basically saying that when she goes back to Momentum Spine, and that's the only place she went back to.
But I don't see that. But I don't see him saying, I see that it's not, I have to admit, I don't usually strike on this basis, but I think his affidavit is extremely unclear. It's like, it says that there's a 19-month gap. It sounds more like he's testifying that it's not causally related, like the plaintiff's attorney said. And this may be the first time I've ever seen a counter affidavit that doesn't specify which bills he's trying to counter. He just says, I guess the ones in 2019, but he's not even entirely clear with that.
Yes, Your Honor, her treatment in 2019 included pain management, anesthesia for a surgery procedure. She had a lumbar discectomy, and she also had an MRI, durable medical equipment, and some prescription medications. And that's from, obviously my review of the records, not from the counter affidavit.
Yeah. All right. I don't usually strike on this basis, but this affidavit, I think, is completely unclear what she's countering, and she doesn't even list out what she's countering. So I'm going to go ahead and strike the counter.
May I, Your Honor?
I'm sorry.
And I had also sought relief that, if there are things that can be cured, which it sounds like there are, if he needs to go into more detail as to specifically what he's referring to in 2019, that we be given 30 days for him to cure his affidavit.
Your Honor, the counter affidavit was filed in March. He's had 4 months to cure any defects if he wanted to, and we've got trial set in October.
Except that we weren't notified of we didn't agree that there was a defect until we had this hearing today.
I will tell you that I am, to be honest, very, very strict with these counter affidavits. And it really seems like what he's trying to testify about is causation. And so I'm not striking him as an expert. You could still have him testify live, but I just don't think that the counter affidavit is appropriate. So, so if you want to call him live, now I will say October, I think there's a significant chance that we may not be back to jury trials by then, but we'll see. I'm not wanting to continue cases in October yet, but we'll see what happens. We're coming up with ideas, but anyway, so I'm gonna go ahead and strike the counter affidavit. Make sure that did you submit an order for that?
Yes, Your Honor.
Let me just look it up. I just want to make sure. Sometimes the plaintiff's attorneys, no offense, Ms. Rivas, will try to sneak in a motion to strike experts, which I'm not granting here. Nope, you didn't do that.
I've actually had that happen to me, Your Honor, so thank you.
Yeah, I've heard about that happening from defense attorneys, so I don't think that's appropriate in a situation like this. So
no, it's not. I've never done that before.
Well, good, Ms. Rivas.
It taught me to look very closely to exactly what plaintiff is asking for in their motion.
Yeah, you gotta be careful about that. So, all right, well, guys, thank you so much. You guys have a good day. Be safe out there, and hopefully you guys will get your computer equipment all fixed up, and we'll see you on the next one. Okay.
All right. Thank you, Judge. Have a good one.
Appreciate it.
Thank you. Good to see you guys.
You too.
Bye.
Okay.
So we have somebody here named Team 2, Bradley. I don't know who that is, or are you
Your Honor, I'm here for the HCB Real Holdings case. It's a motion to modify a receiver order.
Okay, let me see if, I don't recall that one. Let me see.
Scott Seidel, the receiver. I'm here as well, Your Honor.
Okay, let me take a look at this.
Or Bill Wolf also.
So this is on advanced healthcare.
No, Your Honor,
advanced
I
healthcare technology.
can give you the cause number if that's more useful, Your Honor. It's 11-2904. HCB Real Holdings versus Richard A. Myers.
Okay, so that's all right. Well, that sounds good. Do you guys want to go on the record on this one?
I think it makes sense, Your Honor.
Yes, Your Honor.
All right, let me. We're here on. Okay, let's go on are we still on YouTube, guys?
Yes, Judge.
Let's go on the record on cause number DC 192904, HCB Real Holdings LLC versus Richard A. Myers and Thomas Wooters. Counsel, make your appearances.
Brad Purcell on behalf of the plaintiff, Your Honor.
Bill Wolf, Your Honor, on behalf of Richard Myers.
Your Honor, Scott Seidel, I'm the receiver in this case, Your Honor.
Okay. All right, let's proceed.
Your Honor, it's the defendant, Richard Myers' motion. Since it does look like this made it to to your desk at the moment, I'm going to go through a little bit of the background. If you recall, there was a judgment years ago, and then recently there's been some activity to appoint a receiver. You signed an order on February 26th of this year. We had a motion for contempt, and you basically signed a new order on June 26th based upon a motion by the other side. The plaintiff asked to clarify some things about it was a 10-day period and notice wasn't given. And so anyway, that's kind of the history. So we had a hearing on the 26th, and you basically, we discussed a bunch of issues, ambiguities, things that I thought didn't make sense. You ordered Richard Myers to have his deposition taken. A date was agreed on. He had some retinal tear or something, and we moved that a week, and that took place last Friday. So the deposition they wanted that you said you wanted us to take, that happened last week. We then filed a motion dealing with some of the issues that we had talked about on June 26th, and there's like 3 and potentially more now that the deposition occurred, because I think there are positions that I didn't really understand, but that's for another day. That was just based upon the questions. There may be another one of these coming at some point. There's a 10-page order here that we weren't part of. We weren't consulted. We didn't know anything about anything. It was just done without any input. So there's a couple of issues that we've put in this motion for clarification and modification. The first is we discussed this on June 26th, and one of the reasons that I set it for hearing was there was another lawyer with Mr. Purcell that Mr. Arzeda, who confessed he didn't know a lot about the exclusive nature of having charging orders as opposed to turnovers. So what we have in this order, and now we're talking the amended order you signed on June 26th, not the original order back in February. Basically, you have the receipt, you take possession of all of the entities and interests of Richard Myers, and then you order that he has to, quote, deliver them with some ambiguities we'll get to. And as we talked about on June 26th, the Texas Business and Organizations Code makes a charging order the exclusive remedy if you have a judgment. And so that was a point of some discussion. And so we have both partnerships, joint ventures, and limited liability companies, all of which your order would require the transfer of those as opposed to a charging order. And that is improper. And we had talked about that. And like I said, there wasn't clarity about how that worked. And so we're back asking to correct that and not have something that is an exclusive remedy ignored. And the case, the primary case that's relied upon by the plaintiff is a case called Heckard. And Heckard is a Fort Worth case, and we can't find that it's mentioned in any other case as applicable. Heckard says generally charging orders are exclusive remedies, not always. Exclusive doesn't mean exclusive to the Fort Worth Court of Appeals. And then it cites a case called Pajot, and that's a Houston 2017 case. And if you're looking at Pajot, it basically says a charging order is the exclusive remedy by which a judgment creditor of a partner may satisfy a judgment from the judgment debtor's partnership interest. But that does not mean that the judgment creditor is deprived of procedures to put the charging order into effect. And then it says that Stanley versus Reef Securities, Dallas Court of Appeals, says that you can turn over proceeds from partnership distributions. And there's actually 3 or 4 cases that say that, including the Goodman Compass case that I mentioned the last time where I was the appellant's counsel. So if you want to take, even with a charging order, you can add to it the idea of a turnover, but it needs to be the distributions. And the response by plaintiff mentions several cases where that is in fact the situation. That is what the case holds, is that you can do, again, these are, think of it as, a catcher's mitt. When the ball gets to the mitt, it's turned over, as opposed to a charging order. It's like the pitcher never pitches it to that catcher, pitches it straight to the creditor. So one is a charging order, and it relates to the entity, and it's a lien on the entity paying, and the turnover is the idea of if, as, and when the ball hits the mitt, you provide it to the creditor. And those cases that are cited by the plaintiff are several, and they talk about that in some detail. But they're all turnover of proceeds, and what this provides for is a turnover of the interest. And the whole notion of these cases is to basically say that when you have a partnership or an LLC, you're not supposed to disturb the entity's ownership. You're supposed to, essentially, the charging order doesn't involve dealing and making, essentially divesting and creating havoc at the entity level. It's just the idea that as the money flows out, it goes to the creditor. I'm going to read from Puja again. It says, thus a Chapter 31 turnover, which is what we have, and receivership order, which is what we have, may be used to monitor partnership distributions and effectuate a charging order. And again, this case is cited in their response. Then it goes on to cite Stanley, Dallas Court of Appeals, Goodman versus Compass Bank, Dallas Court of Appeals. I'm appellant's counsel in that. But again, in every one of those cases, it's the distributions from, it's not the interest itself. Okay. This one case, Heckard, goes on to say that you can transfer the interests. There are exceptions, and it finds that this is an exception in this Fort Worth case. And they find that the entities are not operating entities that were the subject of that turnover and receivership. And in that case, there was also a charging order in place. And in that case, the debtor was 100% owner of the entity that was subject to turnover. So the idea is that you have a turnover that applies to the only person who could complain or have any issues, because the debtor doesn't have any other owners, that would be that the exclusive notion of a charging order is intended to address. We have here, I think we're talking, I'm not sure because it doesn't say what entity that they're trying to get this on, but from the deposition, there is a limited partnership, and the limited partnership is an operating business. And as was testified, and Mr. Siddell said at the last hearing, Mr. Myers has 39% of that entity. He is not the exclusive owner. And I know that because our firm has a security interest in actually that entity from, I think it's October something of 2012. So 8 years ago, it was done. That one case doesn't apply to these sets of facts. And again, exclusive means exclusive. It should not be. I guess what they're intending is that to deliver those limited partnership interests or LLC interests or joint venture interests, we're supposed to actually just transfer them. And there's all kinds of issues under the documents. And then, like I said, it's the exclusive method is through charging order. One more point that's in our motion is that the charging applications were filed in this case by the plaintiff, one in 2016 and one in 2018, both with proposed orders, but nothing was ever signed. So there was a clear understanding that charging orders were the way, and there's tons of entities. I think they just looked at any entity that looked like it might be related and they put it in there. But there are no charging orders in this case, even though there's 2 applications in 2 different years with 2 different orders, but never signed. So, Your Honor, the first point, and then maybe I should have a response to that before I go on to the second and third issues, or I can continue, it's up to you. But the first issue is that there shouldn't be a receivership over defendant's interest in all entities defendant owns as provided in paragraph 1. And we shouldn't have to deliver interests in limited liability companies and partnerships in contravention of the Business Organizations Code. And the case that's cited, Heckert, has nothing to do with this. Should I continue or do you want to address that first issue? There's 3.
Go ahead and finish.
Okay. The second point is that there is a huge amount of ambiguity in exactly what is referred to by the receivership records, and ambiguity, and also just the breadth of it. I'm going to give you some of the items. The records, also computers. I'm assuming that we would, under this order, have to, I guess, laptops, computers, we'd have to give them to Scott Siddell as the receiver, because if they quote, which through or upon which information be recorded or preserved, means that they would get our computers, which would have our privileged communications, would have medical information, HIPAA. It would be just unbelievable, really. And it says that. And I wrote a letter long ago on June 22nd saying that I didn't understand really what these things were about, and I've really got no response. I got 10 pages of an order, and the program seems to be figured out, and if we don't like it, we'll file a motion for contempt, and that's where we are. Then it goes on to say, including but not limited to memorandum, notes, letters, bank records, statements, checks, wire instructions, confirmations, tape recordings, electronic and digital media of all types, audio and video recordings, and photographs of the defendant. And I have no idea how I respond to something like that, because I don't know what tape recordings they're talking about, or social media, or video recordings of what, and photographs of the defendant. I confirmed he's got kids, when he was a little baby, like 55 years ago, there's photos of the defendant. I don't know why we're doing that, or what the purpose of that is. Or is that really what they're talking about? Or is it missing some words or something? But the idea that I'm turning over all of my clients' photos and images with no restriction on age. So I guess even when he went to the prom, we've got that picture. I don't understand this. And again, when we don't do something, it's like, hey, that's not consistent with the order. We're going to file a motion for contempt. And I'm sitting there going, okay, can you help me understand what you're looking for? I don't think it's his photos. He's not a, you know, a Kardashian or anything like that, where these things are valuable. So again, that's kind of the clarification of the second one. And then the third point is that paragraph 3 of the order, we talked about this at some length at the last hearing. Paragraph 3 has this like schizophrenic quality where the first sentence says that until further order of the court, all non-exempt assets under the control of defendant or under the control of defendant are frozen except as otherwise specified herein. That essentially, in my view, is nothing more than saying that's in custodial legis, and it's got the escape valve of except as otherwise specified herein. There's nothing in this order that unfreezes anything. And then it goes on to say in the second and third paragraph, the defendant and his respective officers, managers, trustees, escrow agents, facilitators, agents, servants, employees, attorneys, and all other persons in active concert or participation with them are hereby restrained and enjoined from, directly and indirectly, transferring, setting off, receiving, changing, selling, pledging, assigning, liquidating, or otherwise disposing of or withdrawing any receivership assets. The next sentence says, this freeze shall include but is not limited to non-exempt funds located in any bank accounts, brokerage accounts, or any other accounts or property of the defendant described herein. So all I'm asking for is to say that we can't have an order that says thou shalt freeze everything. You can't transfer anything and have the other side, as they've done, say I'm in contempt because I haven't actually transferred it to them. I'm sure that's what's intended. It's just the order is schizophrenic. It says you must both transfer and thou shalt not transfer anything. And it seems like, as I said in my letter on June 22nd, tell me which of those provisions you'd like me to violate, since obviously I cannot do both. So that's it in a nutshell, Your Honor.
Response?
Yes, Your Honor. First, I want to give a little context here. This order was entered on February 26th of this year. Mr. Wolf has appealed the order. There was an amended order. It changed about 3 words of the original order, none of which are the subject of this motion. So why 4 months after the order was entered is Mr. Wolf feigning some sort of confusion that needs clarification? And the reason is that he's hoping.
But let me ask you about this. What about this issue? You want the receiver wants the photos? What does that mean exactly?
Your Honor, what it means is Mr. Wolf is selectively reading from the receivership order. Paragraph 1, which defines receivership assets and receivership records, very specifically says that these are the non-exempt assets and then records related thereto. Right? The court hereby takes exclusive jurisdiction and possession of the non-exempt assets, and then it goes on a list. What are non-exempt assets? It's a huge long list. And the non-exempt books and records, including, and then there's a list. So we're talking about the non-exempt books and records that relate to the non-exempt assets, all of which are in the exact same sentence. Mr. Wolf is selectively reading from the order to try and cause confusion, as he's doing with this issue of the freeze. Paragraph 3 very specifically says, until further order of the court, non-exempt assets under the control of the defendant are frozen, except as otherwise specified herein. And then it defines the nature of that freeze. What is the nature of that freeze? It applies to anyone who gets a notice of this order, and it applies to all non-exempt assets. So all assets are frozen by everyone anywhere except as specified further in the order. The order later specifies that the defendant is to turn over those non-exempt assets. So he can't transfer them except turning them over to the receiver. Mr. Wolf is selectively picking and choosing to try to cause confusion. The order is perfectly clear. Mr. Myers, the defendant here, can't transfer assets to anyone. He can only turn them over to the receiver. Same thing with the receivership records, Your Honor. There's no confusion in the order. Mr. Wolf is trying to get a modified order 4 months later. Why? And as he said, he brought this issue up months ago, that he thought there might be some confusion. He wants an amended order, Your Honor, so his client can avoid contempt. And there will be a contempt motion coming shortly. And it's not because of some hyper-technical reading of the order that's very confusing. The first motion for contempt, Your Honor, was because his client did not provide one piece of paper that was a receivership record. Nothing. He turned over nothing, no assets, no records, nothing. So we filed a motion for contempt. What other choice do we have when the court orders him to turn things over to the receiver, and they don't even respond to the receiver who's on the line, Your Honor, and he can tell you that he didn't receive anything despite many phone calls and emails. And what did we find out at that deposition on Friday that Mr. Wolf spoke of a moment ago? His client is egregiously violating this court's order. And I'll give you the most egregious example of many. And this will be the subject of a motion once we get the transcript. His client's receiving about $400,000 a year in salary from companies that he controls. And for about $300,000 worth of that salary, his client received biweekly checks. They were deposited into his checking account every other week, tens of thousands of dollars. Miraculously, that automatic deposit stopped once this court's receivership order was in place. So I asked him, what happened? Where's that salary? It's not being deposited in the account we have records about now. And his client testified he was getting physical checks. I said, well, where are those checks? You didn't give them to the receiver. I've never seen a copy of any of them. Where are they? He didn't know. Checks from February, March, April, May, June, July, tens of thousands of dollars in checks he's getting. He said he just didn't know where they were. It was possible some of them might have been in his desk drawer in his house. When really pressed on this issue, he said some of them his wife took and deposited into her personal bank account. Your Honor, that is as egregious a violation of your order as you're going to find. And that's why Mr. Wolf now wants to modify the order. His client is caught with his hand in the cookie jar. He's been taking receivership funds, giving them to his wife, and they're going into her bank account. And the rest are just stuffed in a desk drawer, maybe. That's why he wants to modify the order. He's hoping to get his client a clean slate here. 4 months later, let's wipe the slate clean. None of these bad acts matter. We're going to get a modified order because there's some feigned confusion about whether assets are supposed to be frozen or turned over. And he's also feigning some risk that his client's going to be held in contempt. That's not what's happening. A motion for contempt was filed because he gave nothing to the receiver, not a document and not an asset. He didn't give the asset list he was supposed to give, nothing. So we had to file a motion for contempt. Our next motion for contempt is not going to be that there was some technical confusion in the order. It's going to be you're hiding money. You're giving it to your wife. Your Honor, there's no confusion here. There's no ambiguity. Mr. Wolf is trying to buy his client.
Let me just go back to my
card.
question again, and I appreciate all of that information, but let me go back to my question. Why do we need to gather photographs? I guess that's my main question.
Yeah, yes, Your Honor. So it's photographs related to non-exempt assets. So if there's a picture of a Ferrari in a garage somewhere, we need that because we need to know where these assets are and what they are. It's
only pictures of non-exempt assets. It's not just because he says it's like his high school prom or whatever. It's not going to include that.
Right, Your Honor. And if you'll read paragraph 1 of the order, it's a very.
Read what the
Mr.
order
Wolf, I'm
said?
speaking, Mr. Wolf.
I mean, you know.
Mr. Wolf, why don't you wait your turn, please?
Okay.
Your Honor, if you read paragraph 1, and it's a very long sentence, it's saying, what is the court taking jurisdiction of? Non-exempt assets, and it describes them, and same sentence, and the non-exempt books and records, and then describes them. Of course, all of these records relate to the non-exempt assets. It's the same sentence. It's for the same reason, right?
May I briefly respond?
Just on the photos.
Yeah, okay, I'm going to read you from the order, the actual words rather than what you just heard. He's right, it goes on and on and on, and then comma, audio and video recordings and photographs of the defendant, who's defined as Richard Myers. I don't think he's a non-exempt asset. Didn't know that really had I don't even know what that means. I mean, it's certainly not what was just said. And photographs of the defendant. That's what I was talking about, because that's what the order says. And then we get this contempt business because we don't know what that means or why. But I don't think that his audio and video recordings and his pictures going back to when he was a baby and at prom and recently when it says explicitly photographs of the defendant, that has nothing to do with non-exempt assets. That's not true. I know that's old-fashioned these days. That's just not true.
So he says it's photos of the defendant.
What would that be?
Mr.
There's a
Purcell.
photograph, if there's a photograph of the defendant wearing a Rolex watch, if there's a photograph of a non-exempt asset, that is something that needs to be turned over. And I mean, it also very clearly says things like bank records. Was that so ambiguous and unclear that his client couldn't turn over any bank records? Checks, wiring instructions. You know, this is feigned confusion by the defendants
We turned over 1,000 pages plus.
after the contempt hearing.
Right, because then there was an order. That's why you amended it, because it didn't exist before. So once we had a real order, we complied.
The
Yep.
amended order didn't change the definition of any of these terms. Again, Mr. Wolf is feigning confusion. The order, the amended order related to the time period of notice that his client got.
If you recall, Your Honor, it said that we had to do things within 14 days, but it was absolutely not disputed that no one saw the order during the 14 days. I didn't get the order. I was told that I was certified mailed it. It wasn't sent. It wasn't served on me. No one sent it to me, so they corrected that. So yes, there is a hiatus when you don't send anyone the order until after the order is supposed to be complied with. So that's why when we got the order, we sent out 1,000 pages and did all this stuff. But I still submit to you, just like I said, and in my letter, that when someone asks for audio and video recordings and photographs of the defendant, and they tell you that's because of a Rolex he'd be watching, why don't you take a photo of the Rolex? I mean, what are we talking? I mean, this is a court order. I got to look at it carefully and comply. I've never seen that. I've been doing this for 40 years. Who asks for photos of your defendant? He's not an actor.
Mr. Purcell, I think this is an extremely minor point, but it does concern me a little bit that this isn't clear. So if we could just do a supplemental order that makes it clear that for any type of photos or social media, that the defendant is not required to turn over any personal photos or social media unless they contain non-exempt property that is subject to be turned over. I think I'd like to just be safe about that. Other than that, I'm going to deny the motion. Anything else, guys?
No, Your Honor, I will circulate a proposed supplemental order to council and then file it with the court.
Thank you, guys. Have a good day.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor. Thank you, Your Honor.
And interns, sorry. Interns, you guys can wait around. Okay, I need to turn off YouTube. So Tony, we